The second announcement I have comes in the form of a ruling that I would give with respect to the motion of no confidence in the Speaker of the National Assembly. Honourable members, on Tuesday, December 13, 2016, during a sitting of the National Assembly, where I was presiding at that time, I was handed documents by the Clerk of the House, which consisted of a cover letter signed by the Right Honourable Dr. Denzil Douglas as Leader of the Parliamentary Opposition, and an attached, unsigned, two-page document which was captioned Motion of No Confidence in the Speaker of the National Assembly. Then, on Monday, January 13, 2017, I received a similar set of documents which was dated December 31, 2016 and captioned, quote, amended motion of no confidence in the Speaker of the National Assembly, end of quote. On examination of these two sets of documents, the one and only amendment that I garnered was the insertion of the word not, N-O-T, in front of the words, quote, to be impartial, end of quote, found in the penultimate paragraph of the original motion, so that it now read, quote, not to be impartial, end of quote. This amended motion is hereby rejected on the grounds that it directly violates section 34(7) of the Standing Order, which states, quote, an amendment must not be substantially a direct negative of the original proposition or of any amendment thereto, end of quote. As such, no further reference will be made to this amended motion.
Could you please reference again the section, Mr. Speaker, on the order paper?
That will be section 34.
Could you please read it for the benefit of all of us?
Okay, honourable members, let me pause here to say
You are not directing the Parliament.
honourable members, let me pause here and say that I am giving a ruling on a particular matter. I would wish to give this ruling in silence from the members, except, of course, for any clarity, which I would tolerate. If you didn't hear the section, I have no difficulty in repeating, but I would not want any major interjections while I'm giving this ruling.
Mr. Speaker, just for clarity, please. You reference section 34, amendment to motions, but I perceive that this is...
Honourable member,
Yes?
I would give my ruling.
So you're not
If I have along the way stated a section, in reference a section incorrectly, we'll have an opportunity to deal with that. But I will give my ruling.
It is mostly inaccurate. So I beg that for clarity, this section speaks to motions that have been debated in this House, an amendment put to those motions, it is saying that someone who has proposed an amendment and passed cannot therefore put a negative amendment to that amendment.
Honourable Member, I am giving my ruling.
Mr. Speaker.
Mr. Speaker,
Honourable members, honourable members,
Mr. Speaker,
Can you do that?
am I going to be given the opportunity to speak?
honourable members.
That is absolutely not what is here. So I should sit and just let you know. This is for motions that have
Honourable
been
members, I'm on my feet. When I'm on my feet, I expect silence. I'm giving a ruling. I expect this ruling to be heard in silence. You're free to make your notes. If I err in any way in giving my ruling with reference to sections, there's a way of dealing with that. I am giving my ruling. If I have any more interruptions while I'm giving my ruling, I will consider that to be grossly disorderly, and I will deal with that occurrence accordingly. This amended motion is hereby rejected on the ground that it is directly in violation of section 34(7) of the standing order, which states 34(8), which states an amendment must not be substantially a direct negative of bringing the original proposition or of any amendment thereto. As such, I will make no further reference to this amended motion. In making my ruling on the motion, it is very important for me to advise as to the procedure which should be followed whenever a motion is brought to the attention of the Speaker. Section 27(3) of the Standing Order of the National Assembly speaks to this and reads, if the Speaker is of opinion that any notice of motion which has been received by the clerk infringes the provisions of any standing order or is in any way out of order, he or she may, I repeat, may direct A, that the member concerned be informed that the notice of motion is out of order, or that the notice of motion be entered in the order book with such alterations as he or she may direct. In a nutshell, therefore, once a motion is submitted to the Speaker has essentially two options available to him. If he is of the opinion that the motion is in breach of any of the standing orders, the two options are: the Speaker may simply advise the member under whose name it is submitted that it is out of order, or the Speaker may amend the motion as he sees fit and direct the clerk to place it on the order paper for debate. Of course, it goes without saying that if the motion is deemed to be in order, then it is expected that it will be placed on the order paper for debate, and I would add, in an expeditious time frame. Before I pronounce on my actual findings to the motion, I deem it important to speak to part of my experience over the period when I have had the privilege to preside in the National Assembly, specifically as Deputy Speaker, between December 2015 and June 2016, and then as Speaker from June last year to present. I state for the record that I have endeavored at all times to be fair and transparent, it being legal and the moral thing to do. I have been very tolerant, and according to a wide cross-section of our community, far too tolerant as it relates to the unacceptable behavior of some members at times. However, I would prefer that I have chosen to be deliberate and strategic in my approach and have instead given members more than enough of an opportunity to demonstrate to the public the type of parliamentarian he or she would like to be characterized as. Honourable members, let us now fast forward to the adjournment of the House at the end of the first day of the budget debate last December. At that time, I forewarned members that I would not be accepting any more unparliamentary type behavior as of day 2 of that debate. In particular, I made it pellucid that I would in effect be adopting a zero-tolerance approach to any exhibition of disrespect to the chair. I was therefore expecting that come day 2 of the budget debate, there would have been a positive turning point in this House and a noticeable all-round improvement here. As our conduct here in Parliament is a matter of public interest and comes under public scrutiny at all times, I can only invite the public to be the judge as to whether or not our Parliament appears to be now moving in the right direction. Honourable members, I now return to the notice of motion itself that has been received. For simplicity, I make no distinction between notice of motion, that term, or motion itself. Having examined the document, I have found it to be fundamentally flawed, fraught with inaccuracies, errors, frivolity, and most importantly, it seriously infringes several of the provisions of the standing orders of the National Assembly. I believe it is only proper and transparent that I speak to some of the more serious infringements. Honourable members, it is obvious to me that the motion seeks to challenge previous rulings of the chair in a sort of broad fashion way.
Point of order again.
No. Honourable member, there shall be no point of order while I'm giving this ruling.
But it seems that you are debating the motion.
Honourable member, there shall be no point of
How can you
order.
debate the motion?
Judge, jury, and executioner.
You can't do that.
And the motion is against him.
You can't do that. How can you respond to it? And I have no time to present this to the Parliament. Come on, man.
That's basic.
Improper.
That is totally improper.
You should excuse yourself.
After all.
Honourable members,
We're out of order.
You're not out of order. But we are out of order.
there shall be silence while I'm on my feet, and I'll say for the last time,
Silence
I'll
on
have-
both sides.
I will have no further or tolerate any further interruptions from anyone. Honourable members, it is obvious to me that the motion seeks to challenge the previous rulings of the chair in a sort of broad way. However, there is a difficulty here in that section 48(1) of the standing orders states in part that decisions of the Speaker, quote, shall not be open to appeals and shall not be reviewed by the National Assembly except upon a substantive motion made after notice, end of quote. I find that the motion as presented is asking Parliament to review past rulings of the chair in a generalized way. And as such, this is deemed totally unacceptable. Each and every previous ruling which is being challenged or asked to be reviewed and which purports to form part of this or any future motion must be specifically identified with accompanying details. Nothing short of this passes the test. According to section 25, section 25, subsection 3. According to section 25(3) of the standing orders, a motion should not contain, quote, mere personal opinions or controversial allegations unnecessary to the main issue upon which the National Assembly is being moved to declare its will, end of quote. I am of the opinion that much of the content of the motion is exactly that, as there are a number of such opinions and allegations instead of statements of facts upon which Parliament would debate and then be asked to pass the necessary resolution. Additionally, all statements within the motion which in any way impugn the character of the Speaker or imputes improper motives are in breach of section 43(5) of the standing orders, which states, and I quote, "No member shall impute improper motives to any member of the National Assembly," end of quote. Just in case we are unaware or have forgotten, the Speaker is also a member of this Honourable House. For the avoidance of doubt, therefore, any charge of or imputation or suggestion that seeks to question the impartiality of the Speaker is considered a breach of the rules of this House.
Mr. Speaker, I have a right in this Parliament to speak
Furthermore,
on behalf of my elected...
Furthermore,
Mr. Speaker, I don't think you should be debating the motion
member
here.
for number 6.
I don't think so.
Honourable member for
I really don't think so.
constituency number 6. This is the absolute last time that I am going to be saying this.
If you want us to leave, then throw us out.
I would not accept any more interruptions on this ruling.
It is
While giving
unfair.
this ruling.
That is what I'm saying. It is unfair and unjust. It is unfair
For the
and it is
avoidance of
unjust.
doubt, therefore, any charge or imputation or suggestion that seeks to question the impartiality of the Speaker is considered a breach of the rules of this House. Furthermore, the motion makes use of phrases and descriptions such as targeting certain members, preventing the member from speaking, unmerited ruling, which when taken contextually are disrespectful of the chair, to say the very least, and again is considered a violation of section 43(5) of the standing orders. Another area of the motion which caught my attention is the section that states, in part, notices for parliamentary meetings and order papers and accompanying bills are more often than not delivered late. That's a quote from the motion, so let me repeat it. The quote is, notices for parliamentary meetings and order papers and accompanying bills are more than not delivered late, end of quote. This is factually untrue. I also find it to be disingenuous.
Even this very meeting, it came late.
Honourable members, Honourable member for number 6,
Yes,
Dr.
Mr. Speaker.
Denzil Douglas.
Yes, Mr. Speaker.
I have indicated previously that any further interruptions while I'm giving a ruling is out of order. You have just you have just interrupted me again. I find that to be grossly disorderly.
Mr. Speaker, I wish to take my leave from this Parliament. This is an injustice.
And
An injustice it is.
I am asking you
Let us all go.
to withdraw from this
I am leaving your parliament. I am leaving. I am leaving.
You throw out the member who is going to move a motion.
I have a motion against you. You are the making the motion. And I can't do it.
You are
Come on. You are the making the motion. I brought against you. You can't tell me out. I will leave. You are unfair. You are unjust in your ruling.
That's what I spoke.
I thought you do better.
That's what it is. You have no personal integrity.
No personal integrity in this party.
You have none. You have none. You mean that's what you know? That's what you know?
I thought you do better. You throw out a member of parliament who has a motion of confidence against you.
What is this kind of thing? What is this coming to? What is this
A
parliament
member
coming
who
to?
motion is against is debating the motion in the parliament. Imagine that. Alright. Throwing out members who have been elected in here. Members in the gallery making noise and even setting. They will come. They will come.
Are you threatening the speaker?
Time now,
It's the most popular government. I'm not the speaker.
Time now, that's one.
Disgrace.
Mr. Speaker.
I continue. Furthermore, the motions makes use, I would have said that. Another area of the motion which caught my attention is the section that states in part that notices for parliamentary meetings and order papers and accompanying bills are more often than not delivered late. This is not true. I also find it to be disingenuous in that members of the opposition who are often late to sit-ins and are frequently absent would bring this charge. The most noticeable example of this disingenuity, in my opinion, could very well be found in the case whereby I used my discretionary authority and delayed the start of the morning session of day 2 of the last budget debate to await the arrival of members of the opposition, and in particular the Honourable Leader of the Opposition, Dr. Douglas, who was expected as per tradition to give the response to the budget address. Having waited, and while making my way to the chamber to begin the proceedings, I received a verbal request from one of the members, the Honourable Member Dr. Douglas' colleagues, on his behalf to further delay the start for about 5 minutes as he was on his way to Parliament. I facilitated the Honourable Member and allowed this delay, even though I certainly did not have to. That morning session was to begin at 10 o'clock, and we did not get started before around 10:40. The motion alleges that the Speaker has done nothing to assist in the establishment of an office for the Leader of the Opposition. This statement is utterly misleading, as the Speaker has no authority in the setting up of that office, as that is a direct matter between the Leader of the Opposition and the executive branch of government. Notwithstanding this lack of authority in me, I have nevertheless inquired into and urged the executive to seek to have the matter resolved. In all of my efforts to date, I have been advised that the formal and official position of government on the matter is that a budgetary amount of some $70,000 was allocated in the past, and it has again been made available for 2017. I have been advised that any additional amount above this figure would have to be met by the Leader of the Opposition. I have been advised by the executive of government, and in fact the Honourable Attorney General has also pronounced in Parliament that this amount of $70,000 represents an increase of over 50% of what was last budgeted for under a previous or the previous administration. So again, I reiterate, the Speaker has no legal authority in this matter, but has used efforts to, in the interest of getting it resolved. The mover of the motion states that the Speaker has done nothing to assist in the establishment of the Public Accounts Committee. This again is a false statement, and it also impugns the character of the Speaker. Since the speakership almost 7 months ago, I have had several discussions on this subject with the relevant members of government, including the Prime Minister, the Attorney General, and the leader of government business. Furthermore, honourable members have committed publicly that this matter would be addressed. As a matter of fact, one such commitment was made only a few days before the submission of this motion. That is, at the budget debate, and it was made by the Attorney General himself. So, once again, honourable members, this statement with respect to the Public Accounts Committee, and specifically the statement that the Speaker is doing nothing about it, is false, and I find somewhat mischievous. As to some of the inaccuracies alluded to earlier in the motion, these would include the fact that the honourable member opposite, Senator Nigel Carty, was not suspended from the House as is stated in the motion, but instead was directed to withdraw from the House. There is a difference, honourable members. The naming of a member results in a suspension, and Senator Carty was not named at that time. He was simply asked to withdraw from the House for the remainder of the days same. Another inaccuracy or flaw that I've found is in the statement that Honourable Conris Maynard and the Honourable Marcel Alibod were prevented from speaking at a sitting on April 27, 2015. April 27, 2015. To the best of my knowledge, and the records will reflect, this Parliament had its first session on May 14, 2015. As to the reference to me as Speaker Michael Nigel Perkins, I repeat, Speaker Michael Nigel Perkins, that's a part of the motion. I assure all honourable members that my full and legal name is Anthony Michael Perkins, and I say no more with respect to that. Honourable members, Section 85(1) of the Standing Orders states, in part, in any matter not herein provided for, resort shall be had to the usage and practice of the Common House of Parliament of Great Britain and Northern Ireland, which shall be followed as far as the same may be applicable to the National Assembly. The House of Commons and our Parliament have as its main resource authority the document entitled Parliamentary Practice, Treatise on Law, Privileges, Proceedings, and the Usage of Parliament, written by Erskine May. In preparing this ruling, I have substantially relied on this authority. That authority speaks to the issue of contempt. Yes. And I will use this opportunity to alert the House and the honourable members and the nation at large that there are things which are being said in the public by some members. There has been behavior demonstrated here by members this morning, which falls, in my opinion, squarely in the realms of contempt. And I invite members to examine section 47(12) of the standing orders, which states, nothing in this order shall, meaning the standing orders, nothing in the standing orders shall be taken to deprive the National Assembly of the power of proceeding against members according to any resolution of this National Assembly. This National Assembly has the authority to move any resolution, and so I use that as a warning to honourable members. Honourable members, having expounded on the many instances that the notice of motion infringed on the provisions of the standing orders, it is only left for me to conclude this ruling by hereby declaring that the notice of motion dated December 13, 2016 and submitted under the signature of the Honourable Member for Constituency 6, Dr. Denzil Douglas, is out of order, and further that this matter is considered closed.